if you do not get it changed on time, if you show up and it's not testable, if it falls off, anything like that is going to be a violation of your bond, and you will have your bond raised and you will be back in custody. No questions about it. Do you understand? So you need to talk to your bondsman. And actually, if you on your way out, there's probation right there. She has a list of places where you can get that as well. So you can stop and ask her for that list. I need proof to your bonds. Mr. Hines, you tested positive for THC. When's the last time you used marijuana?
3 weeks ago.
So you're trying to get a job, you have jobs, and you know you're going to get tested on jobs, especially the type of job that you're doing, and you're using marijuana.
You know, I ever since last call, I've been trying to get clean. I had stopped smoking. Since I got the job offer from multiple job offers, I had stopped smoking. See, right now I just do has a little work for cleaning up trucks with CDL. I'm also in class and try to get my CDL. So that's what I've been getting my little money from.
So here's what you're going to do, Mr. Hines. You're going to get a drug patch. You're going to get it on today. You can ask your bondsman where to get that. You're going to wear your drug patch. Obviously, it's going to test positive probably the first go round. But if you're telling me the truth about 3 weeks, then it should be going down and be negative within the next patch. You have to get them changed every 2 weeks. And today that you have a drug patch on your arm. Okay? All right, step in front of the clerk. She'll give you a reset notice.
Yes.
No. Right here, in front of her. Good morning. Are you paying Downhauer? Ms. Downhauer, it's very important that you're here on time. I forfeited your bond and reset it at $100,000 because you weren't here.
I'm going here. I've been here since 8 this morning.
Well, they called your name.
I was in those doors asking which courthouse I was supposed to be in.
Okay. I'll recall the bond forfeiture. And so, Ms. Downhauer, this is your initial appearance in cause number 26, DCCR 0906. You're charged with a second-degree felony offensive assault on a peace officer, and that's from March 20th of 2026. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, I asked for one to be appointed.
So when you're in custody, we automatically grant that and give you an attorney. But once you make bond, I'm going to expect you to at least try to hire your own attorney. So what I'll do is reset your case for about 30 days to give you some time to try to get someone hired. If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do.
Yes.
If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me the names of the lawyers you've talked to so I know you're trying. Then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order and you would go back to jail. Do you understand? Give me just a second to take a quick look at something. All right, step in front of the clerk. She'll give you a reset notice. If I call your name, come forward, please. Derek Chapman. Chatham. All right, if I call your name, come forward, please. All right, so you're Derek Chatham?
Yes, sir.
And Mr. Chatham, this is your initial appearance in cause number 26, DCCR 0904. Just a second.
Please.
You're charged with the state jail felony offense of forgery of a financial instrument from January 29th of 2026. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Not yet.
So what I'm going to do, sir, is reset your case about 30 days to give you some time to try to hire someone.
Yes.
If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand?
Yes.
All right, if you step in front of the clerk, she'll give you that reset. Shh. Son's not here. Paul Malone. Paul Malone. Paul Malone. Pretty good. President Ron, all the way up. Good morning. You're Paul Malone.
Yes, ma'am.
And Mr. Malone, this is cause number 20-34762. And it looks like you have a motion to revoke your probation on probation for unlawful possession of a firearm by a felon. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Yes, but I can't afford a lawyer.
Well, how did you afford that bond?
My mom paid 1,000. I'm paying off 100 every 2 weeks.
Are you working?
Yes, ma'am.
Okay, so what I'm going to do is reset your case to give you some time to try to hire someone. So if you get someone hired before that next court date, you just need to bring the reset notice that you get today to that lawyer and they'll tell you what you need to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and we'll discuss what your options are. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order and you would go back to jail. Do you understand? Let me look at something real quick. So as a condition of your probation, obviously, look. Where are you living?
I was at the behind Tammy's at RV,
Mhm.
but my air conditioner broke, and now I'm staying with a friend at the apartments. But I told my PO he's out there.
You did?
Yes.
And you've got that GPS monitoring device?
Yes, ma'am. I was wondering if I could get it off because
No.
I can't really afford it.
Nope. That was a condition. That's one of the few things that made me comfortable setting the bond in your case back when I set it. So that's staying on so that I know for certain and I'm comfortable that you're not going anywhere that you're not supposed to be. All right. So I need you to try to get a lawyer if you can before that next court date. And then we'll see where we are. Okay. Make sure you bring the names of who you've talked to if you don't hire one.
Yes.
All right. Step in front of the clerk. Hannah Ballard. No. Good morning. Are you Hannah Ballard? Yes. And Ms. Ballard, were you able to get someone hired? Who'd you talk to?
Ripe F. Ripe S. Kimler, and Winston Scott Adams.
Okay.
And I was going to see if I could get Mr. Kimler hired, but he told me to come back to his office for us to talk about price because he didn't give me the price that day I got his card. Because he was in another meeting with someone.
Okay. So but you've had a whole month to try to do that. So you can't wait till the last week to try to go see a lawyer because they're busy. You've got to go as soon as we're done with your court date. Is that all you just talked to 2, not 3?
And Philip Dowden, I didn't get a card from him.
But you did talk to him as well. All right. So Ms. Ballard, I'm going to reset your case one more time. Don't wait till that last week. Go visit with Mr. Kimler. If you get him hired, great. Bring the reset notice to him. If for some reason that's not going to work, talk to at least 3 more. Bring me those names and then we'll discuss your options.
Yes, ma'am.
Okay.
And my employment, I don't want to, without telling you, I'm no longer employed at Dollar Tree because I had a situation with allergic reactions. But I did still do what you told me to do, and I was applying to every jobs that I could.
Okay.
And I got an interview at Cascades, nursing home
Mm-hmm.
for next month on the 6th.
You do? Okay. All right. So you're not working at Dollar Tree anymore.
Mhm.
So let's do this, Ms. Willard. I'm going to have you fill out some paperwork this morning to see if you qualify for employer. You need to fill it out accurately and completely. Don't just leave it all blank. You're going to swear under oath that it's all true and correct, and then I'll take a look at it. You step in front of the clerk on the end, she'll give you that paperwork. Hagan, down hour? Down 4 hour? Hagan, down hour. Sure. Hagan. Oh, come on.
Or it doesn't shake them, makes me not hurt.
Does she? You just know, I mean, this is how it's spelled.
Yeah.
No response, Sean?
Right, bond will be forfeited for non-appearance and reset at 100,000. Rodney Hines. Good morning, sir. Are you Rodney Hines?
Yes, ma'am.
And Mr. Hines, did you get someone hired?
No, I talked to a few lawyers, because of my background, they want a significant amount of money.
Who'd you talk to?
Talked to, Brittany Holmes, Ryan Gertz, Corey Crenshaw. Talked to right from the, secretary. I'll probably go meet her when I leave. They just wanted to have money down because of my background. But they will get high.
And where are you working?
I got a, it's working at the port. I got a, another interview at AWP, safe when I leave.
So you not working at the port right now?
No.
Why not?
But they was at a job in corporate, so I can go a couple of months.
I'm going to, if I test you this morning, you gonna have anything in your system? Let's double check that and then we'll talk about your options. Have a seat in the jury box.
Boy.
David LeBlanc. David LeBlanc.
Hey. No response, Sean?
Bond will be forfeited for non-appearance and reset at 100,000. Tara Lynn Williams. Good morning. Are you Tara Lynn Williams? Yes or no, please?
Yes, ma'am.
Ms. Williams, you okay this morning?
Yes.
If I test you, you gonna have anything in your system? No? Let's double check that. Have a seat in the jury box so I can get you tested. So the next one, Donna Hill. Yeah. We don't have any, who's supposed to be sending us the findsman maybe? Okay, I'm not gonna call the name, just hold it and I guess maybe reset it a couple weeks and see if we can get something from them. Javon Johnson. Good morning, you're Javon Johnson. Did you get someone hired?
I'm dealing with Miss Holmes. She has a $1,500 retainer, and she's letting me break it up in payments. If you would give me 2 more weeks and I have to get it paid off.
Okay, sounds good, Miss Johnson. I'll reset your case. And what I'll do is 3 weeks.
Yeah.
And that way you can get her paid and hopefully that'll give her time to get that information to us. And then that court date might change. Get your reset notice, be here on that date unless she tells you otherwise. Okay, thank you. Gilbert Robinson.
Down Howard.
Okay. Good morning, sir. You're Gilbert Robinson.
Yes, sir.
And Mr. Robinson, did you get someone hired?
Did not, but I found somebody very like.
Okay. Who are you planning on hiring?
His name is Phil Gomez.
Yeah, so.
Gomez. I can't remember how to spell his last name exactly.
Where's he out of?
Out of Harris County.
Okay. And you're planning on hiring him?
Yes, ma'am.
Say it again.
Yes, ma'am.
Say the last name
Oh,
again.
sorry, Gomez. I want to say it was Gommils.
Okay.
May have been ELS. I can't remember how to spell it.
Philip, okay. And so if I reset your case one more time, you think you'll be able to get Mr. Gomez hired?
Yes, ma'am.
All right, so I'm going to reset your case one more time. If you get him hired, bring that reset notice to him. He'll tell you what to do. But if for some reason that's not going to work out, make sure you talk to at least 3 others. Bring me those names and then we'll discuss your options.
Been the best option so far.
Okay, sounds good. Step in front of the clerk. She'll give you that reset notice. Hagen Downhauer.
Thank you.
Yeah, very well.
He's up real.
Nick, when you name your daughter Peyton.
Thank you.
Okay.
Who? Okay. Thank you. Ms. Holmes, I'm signing the dismissal of Mr. Behrman's case now, so he's free to go. Mr. Barrington, you've got Alexander Thornton.
Yes, ma'am.
Mr. Smith?
May I approach?
Yes.
Yeah.
Are you smart?
Good, how are you?
Good.
So it looks like I've received some information that Mr. Thornton is currently in the Jasper County Jail.
Yes, ma'am.
And the case is set for trial to begin with jury selection next Monday, which obviously we can get him for that. So what is your announcement?
I believe, talking to Mr. Barrington, that his disposition towards resolution of this case has changed. I think he will want a trial once he disposes of his cases in Jasper.
He's taking a pen time plea in Jasper. Is that next several days?
So he's going to take a deal here or want a trial here?
He's gonna want a deal. It's that I've already visited.
Okay, I thought you just said the opposite.
Oh,
Sorry.
ma'am, I said I think this case will be resolved once he's disposed of those cases in Jasper because he'll.
We're gonna take care of business upriver.
What day?
Is that it's not scheduled as of yet. Is that I talked with the prosecutor. I texted back and forth with the prosecutor on Friday and also yesterday. Is that we're working on the date right now. Is that I was going to try to do it today, but I had this so on my calendar.
I've talked to Mr. Boyce, Daniel Boyd, from my office.
I guess the reason I'm asking is it's obviously one of
No, you need to
my,
get taken care of.
it's very old. And so if what I'd like to do is if that can get taken care of this week, we can get him here and have him plea next Monday.
I don't believe it can based on the holidays and Judge Gibbs has had some medical issues and some other things. And so I'm not sure what that court schedule is. is that as far as that goes.
All right. But you're confident that this is going to be taken care of with the plea?
Yes, ma'am.
Then what I'm going to do is take it off the trial docket, reset it to a plea docket in about 30 days.
Yes, ma'am. I
And
would ask
get
that,
it-
since because he's being held without bond up there, if his bond could go ahead and be revoked, that way there's no issue about time credits or anything.
So what I'll do at this time is find that he's at large without proper bond, and revoke the bond that he currently has and have no bond on that cases, on all cases.
Okay.
Though, so that he'll be getting credit starting
I
today.
appreciate that, Judge.
And let me know when we take the plea, if there's some time that he was in custody there, even though he was technically on bond here,
Yes, ma'am.
We'll
I
look at
appreciate
that.
that because that's been an issue with him in the past.
I'm not saying for sure it'll
No.
happen, but just kind of take a look at it and we'll discuss it
I
at
understand.
that time.
Thank you, Your Honor. I
Thank
appreciate that. Thank you. Thanks, Bill. Thank you, Judge Moby. Excuse me.
Yes, sir. Thanks.
Thank you. Yeah.
Mr. Jeffries, you got artist McCoy.
Yes.
Good morning. Good morning, sir. You artist McCoy Jr. And this is 26 DCCR 0516. Mr. McCoy's charged with driving while intoxicated, third or more. And what is the announcement?
We would ask for a reset, Your Honor. We have a couple of discovery issue that should be resolved very quickly, but also there's some other.
Judge, he's gotten video discovery for some reason, and I think it was just an error. He didn't get added on paper discovery. We need to fix that. Plus, Mr. McCoy has at least 3 lab reports that are pending completion, both from this offense state and in different offense states.
Okay. And so is there another offense potentially coming, or is that not going to be?
They all 3 are suspected cocaine, so I'd expect at least 1 or 2 new cases to be coming.
All right. So let's just do, I'm going to do about 45 days, see where we are. If you can get with, obviously, the quicker the lab can get that done, that would be great. And then we'll see where we are at that time. Stay in touch with Mr. Jeffries. He'll let you know when you need to be.
Does he have, what kind of device has he been ordered to have, Your Honor?
Well, I would think that Mr. Jeffries would have to, Mr. McCoy. Are you wearing, do you have the auto ignition interlock device? You have the patch as well.
Patch is my concern. So as long as he has a patch and it's not been reported. then-
Have, let me look at something real quick. That patch was a condition of your bondsman or of your bond when you left jail. The magistrate told you that, or your bondsman told you about the patch?
Drugs in jail.
Okay. And so when did you get out of jail? How many times have you switched out that patch?
I haven't yet because I went to a inpatient program. So
Okay. So,
Monday is my first time.
so here's the thing. If you wear it longer than you're supposed to, it's not testable.
Right. It's I go next Monday coming is when I walk
You're
out.
2 weeks. Okay. All right. Perfect. All right. Make sure, obviously, if that shows positive, I get those results now that that's ordered. If it shows positive, your bond's going to get raised and you'll be back in custody. So do whatever you need to make sure you're on time getting them changed and that they're testable every time. Okay. Anything else?
Yeah.
All right. You're free to go. Stay in touch with Mr. Jeffries. He'll let you know when you need to be back. Thank you.
Thank you, Your Honor.
Morning, Mr. Nichols.
Good morning.
Mr. Johnson? He must be walked outside. Mr. Lewis, looks like you're working on some paperwork.
Yes, ma'am, for
Okay.
Mr. Killer.
Okay, I'll hold your other one while you're doing that, and then we'll take care of both of them. It's Charlie, Mr. Rojas. This is a little docket. Mr. Smith, Dontrell Scott. Good morning, sir. Are you Dontrell Scott?
Yes, ma'am.
And this 25 DCCR 0504, Mr. Scott is charged with official oppression, and looks like there's a notation. This was the last announcement. So what is the announcement?
The announcement, Judge, is that I really messed this up. I was confused as to whether or not I made a request for pretrial diversion. The state did. So I completely messed that up, Judge. I need to make the request, not the state, which I will do. I screwed it up. It's my fault, Judge.
This felt like that could have been done back in August of last year.
That's
A year ago, almost, you were
That's absolutely correct, Judge.
hired on this case.
That is correct, Judge. I spoke to the state about it, and then I just
What's the time frame on them, if we ask for,
We should know within what one. We said,
okay. All right, if, get that in, this will be, regardless if there's any issues, the something will have to be done at that next court date. We'll do a normal reset. You need to get it in quickly because I know,
I'll do it before I leave the building, Judge.
Okay.
I just really just got confused.
that's okay. And so if you don't mind, Mr. Smith, letting Mr. Canal know that the sooner the better on that one. I know he's probably got a pile of them, but if he'll kind of stick this one to the top when he gets it,
Yes,
that'd be great. Thank you.
Thank
Right.
you, Judge.
Stay in touch with your attorney. He'll let you know when you need to be back.
Appreciate you.
Yes, sir.
Well, that's good for you.
As soon as it comes through, I'll call you back over.
Good.
Mr. Hines? Oh, wow. Thank you.
I'm on your side.
And are we going on just count one? Well, we won't. Yeah,
Yeah, just count one. The priors for the district.
right. Okay, give me a second. Okay. In there. All right, Mr. Williams, in cause number 24, DCCR 2242, the state's elected to proceed on count one only. It alleges that you committed the third-degree felony offense of driving while intoxicated, March 31st of 2024. The indictment further alleges that you were previously convicted of driving while intoxicated, March 28th of 2014, and also May 2nd of 2022. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
And because you did what they charged you with?
Yes.
And are those two prior convictions for DWI true?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Johnson?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 8 years. You would be ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation, and that would include those 10 days upfront time. Do you understand?
Yes.
Do you also understand, sir, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
Objection, Your Honor.
It's admitted. Is there any evidence that Mr. Williams is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back at a later date for sentencing. On your way out of the courtroom today, you need to stop and talk to probation, and she's at that desk right behind you.
Okay.
All right, we'll see you back at sentencing. Thank you.
Thank you, Your Honor. I'll go take care of that right now.
Thank you, sir. was for the second degree felony offense in possession of a controlled substance. And then in October, okay. September of 2017, same date, also put on a 5-year adjudicated probation for the state jail felony offense of possession of a controlled substance, clause number 172669. And so this is 172688. We were previously in court. Mr. Barlow entered pleas of true to counts 3, 5, 6, and 7. So we're just here in the second degree felony. The other one's already expired. I received an updated report. Have you both had an opportunity to review that report?
Yeah, Judge.
Yes, Judge. Any additions or corrections?
Oh, not from the defense judge.
Not from the state judge, other than I think we have all previously discussed this before, that the new offense allegations all occurred in Harris County, and we waited some time for those to resolve themselves, which is why we're not proving.
Okay. And they haven't resolved themselves,
No,
or they have.
No, we're currently set for trial next month. I want to say the 20th or 22nd of July.
Well, okay. So what he pled true to was failure to remain in Jefferson County, failure to report the arrest, positive urinalysis, and failure to pay fees. And everything else had to do. Let me double check. Yeah. Okay. So everything else has to do with the cases over there.
Yes.
All right, Mr. Lewis, and there was no agreement. Mr. Lewis, you may proceed.
Well, Judge, since he's been on bond, he's been on house arrest. And I think that probably was one of the best things that happened to him, because it allowed him to, one, find stable employment, which he's been able to do, and recently been able to actually find a nice stable housing situation for him and his children. He's basically operating as a single parent, because his wife still legally his wife. She's in Harris County. He's here with the children. He's raising the children himself. So he's been able to find employment, find housing, and he's been doing this on his own. He's currently even, you got to see the bandages there. He had a situation where he had a burn incident, and he still was able to continue employment and continue working to take care of the children. So I know that the recommendations, of course, of probation have been either ISF or some type of zero tolerance of high risk caseload. We would ask that he will be placed on some type of high risk caseload where he will be able to continue that on, because I think any type of incarceration right now would be counterproductive with all the progress he's made over the last few months, Judge, and given his motivation, I think it'd be really good for him if we can continue that on, to especially taking care of those children.
Ms. Golfino?
Judge, I'd like to see if Mr. Kitchens has anything to add other than his report, and I have a couple comments.
He has been doing, since he's been on bond and in house arrest, I will agree with Mr. Lewis saying he's got a different attitude. He has been tested positive with the probation department, and it sounds like it's made a difference.
Okay.
And that's what I wanted to see, Judge, if you concurred with that. I would agree with Mr. Lewis that as many times as we've dealt with Mr. Barlow on this case, on other issues in the past, I mean, I felt like I've had him on my caseload for 5 or 6, 7 years. I don't know that derailing him now is beneficial. I know that the issues with this female friend or wife or whomever is obviously, you got to get that straightened out.
I'm sorry to interrupt. What's the long-term?
Actually, when y'all put me on house arrest, that kind of like it was hard for me to get away from because of my wife and my 2 kids. When I put in my hospital, I've been on it for 6 months. So no contact, only way I could contact through my mom. So the feeling that I had before is gone. Finally, y'all gave me a chance to get a job. I thank you for that. Got the job, worked as a regular worker. They just upgraded me to a supervisor. Been trying to pay 2 or 3 times a week, month. You know what I'm saying? I've been clean. I've been happy that I could take care of my kids and do things I couldn't do, which was real hard for me at the time because I was so focused on her. But through these 6 months, y'all kind of fixed me to a different position to see that I can do better without her.
So the long-term plan is not to try to reconcile and get back in that situation.
It really just, it pushed me away because without this, I probably would have been still trying to be in a relationship with her, try to keep my family together. And Mr. Lewis
Sometimes that's not the best thing for the kids.
Mr. Lewis had conversation with me as well on the side after coming from court in Houston and saying maybe this ain't what. You know, my dad haven't been there to tell me nothing. I've been dealing with Mr. Lewis about 8 years. And like I told him, he done told me a lot of father figure things that kind of dawned my brain that I couldn't even focus on without another male person that's in a good position in life to kind of direct me. So it kind of put me in the right stand. And Mr. Kitchens always was out to hear what I had to say. And I appreciate him as well.
Well, here's the thing, Mr. Barlow. If I give you this opportunity today, you've got to take advantage of it because you're not going to get this opportunity again. You've got everybody behind you. Mr. Lewis has worked very hard. I've signed, I don't know how many times he's sending over emails. Can he go do this? He's got a job. Can he? And I want you to do all those things that are positive, but you've got to stay on the positive track when things kind of lighten up a little bit eventually on probation. You're going to have to do it on your own. So what I'm going to do, I'm going to find that you entered your pleas of true to counts 3, 5, 6, and 7 freely and voluntarily. Find those counts true, find sufficient evidence to revoke your probation, but I'm not going to do that today. I'm going to continue you on probation. I am going to order that you're on the high risk specialized caseload and that it's zero tolerance. That means you just have to do it all right. You know, there's no hiccups anymore, no contacts, communication with Miss Foster. Continue doing what you need to about your kids through your mom. If that's working, then that's great. Use that. If that's not working, then there needs to be something else done. And I would think that to help you guys, it's once you get this taken care of, you need to save up what you can and get someone. You can talk to Mr. Lewis about helping you through the family court system so that y'all have some orders in place with regard to the kids. And there's not all of the communication that you might have to have now because things aren't set on who has what and doing what. But as far as I'm concerned, this is going to be your opportunity. No contact. I mean, I'm not going to leave you on house arrest anymore. I want you to go work and do those things. You cannot leave Jefferson County. If she comes to Jefferson County, you better avoid her. If she shows up, you better go lock yourself in a closet and call the police and say, I'm trying. She's bothering me. She can't give you permission to violate my order. Okay. So she can't say, it's okay. Let's just talk about the kids. It's not okay because you're going to end up in prison, not her. Does that make sense?
Yes, ma'am.
All right, so I'm handing you the trial court certification. This wasn't an agreement. You can talk to Mr. Lewis about that. And if there's anything else, Mr. Kitchens, that comes up that you think would be a good condition to add that would help Mr. Barlow, then just let me know. We'll make that happen. Good luck to you. Thanks, Mr. Lewis. Broderick Guillory, Mr. Lewis. It's nice when they listen and. Good morning. Are you Broderick Guillory?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He does.
Mr. Guillory, in cause number 25 DCCR 1716, you're charged with the state jail felony offense of burglary of a building from February 3rd of 2024. How do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand that?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like that agreement that you've reached is for a 3-year deferred probation. There will be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number one.
No objection. Yeah.
It's admitted. Is there any evidence that Mr. Guillory is not competent? All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Ms.
I'm looking,
Malvina?
Judge. It looks like what they alleged is not the right word, but what they stated was that the appliances were approximately $1,000 each, and the window to be repaired $600. That being said, that's in the offense material. They have failed to, since 2025, submit a restitution request at our letter request. I don't have a problem waiving the PSI if you want to do maybe an amount not to exceed, but that's all the information I have. I will send another letter.
I think since restitution is a possibility, I'm going to go ahead and get the pre-sentence report done. That way they can also reach out potentially if there's any amounts that get confirmed between now and then, we'll do sentencing then. So again, find sufficient evidence to find you guilty. But what I'm going to do is reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, more specifically really about the restitution that could potentially be ordered. So if there's restitution, if there was something that did not get returned or things that were damaged, then that is going to be part of your probation that you pay that back. And so we're going to go through this process so that they can see if they can get those amounts. When you're leaving today, you need to stop and talk to probation. She's sitting at that desk right over there, and then we'll see you back at sentencing in a few weeks. All right. Thanks. You're free to go.
Thank you.
Mr. Rojas, you've got Claredessa Beal. Morning.
Good morning.
Good morning. Are you Claredessa Beal?
Yes, ma'am.
And Ms. Beal is charged with unlawful carrying a weapon on alcohol premises and cause number 26 DCCR 0224. And Mr. Rojas, what is the announcement?
Judge, I'm asking for another announcement date. I don't know if this qualifies, but I'm going to ask Mr. Canal for pretrial deliberation in this case.
Okay. Any issues?
No, Judge, and we have extended an alternative offer if she's not ready for that.
All right. So Ms. Beal, I'm going to reset your case about 30 days or so Mr. Rojas can make that request. Stay in touch with him. He'll let you know what he finds out, and then we'll see you back at the next court date.
Yeah,
You're free to go.
Oh.
Corbin Rayleigh. Good morning. Are you Corbin Rayleigh?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Rayleigh, in cause number 25 DCCR 1482, you're charged with the state jail felony offense of engaging in organized criminal activity, and that's from September 28th of 2025. And how do you plead to that charge?
Yes, guilty, right? Something. Right.
So did you do this?
Did you do it or did you not do it? If you did it, it's guilty. If you didn't do it, then it's not guilty and we have a trial.
I committed a misdemeanor under that.
The underlying offense is a misdemeanor assault, Judge, because it was in combination with 3 people or more. He feels it should be a misdemeanor, but Mr. Coleman and Mr. Nichols would reduce.
And you've talked to him about what engaging in organized criminal activity means. So you've gone over all of this with Mr. Rojas, right?
A little bit, yeah.
All right, I'm going to hold the case. Y'all go talk
Yeah.
Ask any questions you have of Mr. Rojas. Listen carefully to his answers. He's
Yeah.
telling you what the law is, and then we'll decide. You can decide if you want to take the deal or not, or if you
Yeah.
want to go to trial. Mr. Wilkerson, you've got Richard Couch. It's a sentencing.
Yes, Your Honor.
Judge, we actually signed new paperwork. We had a discussion this morning. Where he no longer wanted probation, so we made a time offer.
Okay.
There have been some life circumstance changes since
Okay.
between the time that we had entered the plea and present day. And so, given the stringent requirements of probation, including those financial requirements, he feels like he would be better served by going ahead and
Okay. You're sent. You might have done it, but it didn't come through on the bottom of the Wilkersons. So since we've already gone through the plea,
We
I
have
don't know that
PSI
I-
report, Your Honor.
so I can just go through this new paperwork with regard to the new punishment page, but we don't need to get a new plea or anything like that.
I don't-
Correct.
no, Your Honor.
Everybody agrees. All right. So you're Richard Couch.
Okay.
And Mr. Couch, you were previously in court and entered a plea of guilty to driving while intoxicated, third or more, in cause number 26 DCCR 0142. When you did that, the agreement was for a 10-year term in prison, but that would be probated and it would be up to me on how long your probation was. And I've got that pre-sentence report, go forward with sentencing today. And as you can hear, it's my understanding that you have come up with a different agreement with regard to your punishment. Is that correct?
Mhm.
And that is shown here on the documents that you signed with Mr. Wilkerson today on the tablet. And did you go over those with him today with regard to that new agreed punishment recommendation?
Yes, ma'am.
And you want me to go forward with that today and sentence you in accordance with that agreement?
Yes, ma'am. I just asked if I can do my affairs in order and
We were talking about him maybe reporting Friday at 6 p.m., Judge, but he is ready today if you can.
Well, I mean, so here's the thing. I'm not going to sentence him and then hope he reports, because that becomes a problem if he doesn't, since the case is technically over. So I can reset sentencing for next Monday, or I can sentence him today. But I can't do the sentencing and then.
Either option's fine with the state, Your Honor.
Judge McClines indicated that he would like to reset sentencing to next Monday if possible.
So, okay. So state tenders these new documents as exhibit number 1, Mr.
No.
Wilkerson.
No objection, Your Honor.
They're admitted. And so here's what I'm going to do, Mr. Couch, and I want to make sure you understand how important this is. I'm going to reset your case to next Monday morning at 9:00. Come in, I'll go through this real quick, get your sentence, and you'll go with the bailiff and start that sentence. If you are arrested for anything between today and next Monday, then it is very unlikely that I will accept this agreement. Things could be much worse. You understand?
yes, ma'am.
Also, if you don't show up next Monday,
Yes.
things would obviously be a whole lot worse. You understand?
Yes, ma'am.
Okay, we'll see you back next Monday then.
Thank you, Your Honor.
Thank you, Your Honor. Big excuse.
Thank y'all. Yes, sir. On Mr. Adams. Do I not have,
No, she couldn't go. She's ready to go now. We're going to take a break.
okay. You can go ahead. I'm waiting on Mr. Adams and Mr. Gertz, and Mr. Rojas is going over that. 5 DCCR 1482. How do you plead?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
Do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Now, it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Do you understand?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Rayleigh's not competent?
No, Your Honor.
So, Mr. Rayleigh, your unwillingness today at first to take responsibility gives me some concern.
Yeah.
What you guys were doing that day was absolutely ridiculous.
Yes.
And somebody could have been seriously hurt.
Yes, ma'am.
A paintball can cause all kinds of serious bodily injury.
Yes, ma'am. And I told Mr. Rojas I'd be willing to do anything civil matter with the victim. You know, I'm not a just horrible person. I'm really
No, I mean, y'all, it was ridiculous
Yeah.
and stupid. And
Yeah.
you're lucky you're not here for an aggravated assault with a deadly weapon by shooting an eye or shooting somebody in the head in the wrong place.
Yes, ma'am.
3 people were shot just driving. You're lucky that y'all didn't get shot because somebody didn't think it was a real gun. And that's what people are doing everywhere now, is shooting people. So you're out there with a paintball gun, but you in turn could end up shot. So I just want to make sure you understand that giving me an opportunity to review this gives me some concern. You need to take advantage of this opportunity. You're very young. There's no reason for you not to be able to be successful and make some better decisions. But you need to understand the importance of this as felony court. Doesn't have anything to do with civil court. Doesn't have anything to do with paying them back. It has to do with you doing your probation right. And if you don't, you go to prison.
Yeah.
All right. So I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing just so I can get a little more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. All right? See you back at sentencing.
Thank you, Judge.
Thank you.
Thank you, Mr.
You're welcome, Mr. Rowan.
Miss Williams? All right, Miss Williams, you tested negative, which is obviously good. You just look very kind of out of it and tired this morning. I'm sorry?
I don't get in trouble.
You don't get in trouble? Well, you're in felony court, so so you're in some trouble at least. So let me go through this with you. This is your initial appearance, Miss Williams, in cause number 26 DCCR 0804. And in that case, you are charged with the 3rd-degree felony offense of theft of property, and that's from January 24th of 2026. And so since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No.
All right. So what I'm going to do, Ms. Williams, is reset your case for about 30 days to give you some time to try to hire someone. If you get a lawyer hired before the next court date, then just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order and you would go back to jail. Do you understand?
Yes, sir.
All right. It's obviously very important too that you don't use any type of substance that would test positive. Okay.
Mhm.
All right. Step in front of the clerk. She'll give you a reset notice. Mr. Adams, you've got Kayla Provost. It's sentencing.
You want a hard copy?
Morning.
Morning.
Thank you, thank you.
Good morning, ma'am. Are you Kayla Provost?
Yes, ma'am.
And this is 25 DCCR 0972. Ms. Provost was previously in court, entered a plea of guilty to evading arrest or detention with the use of a motor vehicle. I have reviewed the pre-sentence report. There was also a memorandum that was sent over a little later from the arresting officer. Have you both had an opportunity to review all of that?
Yes, and I did get the email from the listing officer.
Yes, Judge. Any additions or corrections?
None.
Not from the state. All right, Ms. Provost, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, but I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 4 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have a felony conviction on your record. And at the end of the probation, if you successfully complete it, you'll never have that conviction. The case will actually be dismissed. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, convicted of the offense, and sent to the prison for between 2 years and up to 10 years. Do you understand?
Yes, sir.
I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. If you'll just have a seat here in the courtroom, Ms. Provost, the probation will call you when she's ready to go over your paperwork.
Thank
Good luck,
you, Judge.
William. Thank you.
Appreciate it.
Yes,
Thank
sir.
you.
Thank you.
I know I should say this. We had one other thing about a GPS watcher.
Good morning, sir. You're Marshall Chance the fourth.
Yes.
And this is 26 DCCR 0370. Mr. Chance is charged with aggravated assault with a deadly weapon. And what is the announcement?
Judge, we're asking for a regular resetting on this so we can review discovery and Mr. Chance and I can meet and start figuring out a game plan.
Any issues, Mr. Smith?
Judge.
All right, so we'll just do a normal reset. Mr. Chance, make sure you get in touch with and visit with Mr. Gertz before that next court date. We'll see if we can get an announcement. All right, you're free to go. And I will hold Mr. Hill while y'all get that paperwork done. You guys filled out state jail felony papers, but indictment shows it's a 3rd degree.
Gosh. Really? It's other guys in the prayer?
Does it matter what the amount is?
Well, look it up. Is it transportation code? 501, that's transportation code? No.
Yes.
Is it?
Yes. 501, 155.
I don't have that in my transportation code.
I don't have any guides. Oh, there it is.
It doesn't say what code it is. It just says 501. Is that?
501, 155B. It says transportation code in the notes. It doesn't say in the caption.
My book doesn't.
It's a F3 in the DPS book.
All right, y'all go figure.
All right, you got it. Judge, I apologize.
Okay, Bruce Hill. All right, sir, again, you're Bruce Hill.
Yeah.
And we are client with the formal reading of the indictment.
Will, Judge.
Mr. Hill, in cause number 25, DCCR 1348, you're charged with the 3rd degree felony offense of giving a false name or information or forging a vehicle registration from July 11th of 2024. And have you pleaded that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Gertz?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 2-year deferred probation. You would be ordered to follow all of the rules and conditions of probation, also be ordered to pay restitution that would be figured out between now and the sentencing hearing or at that sentencing hearing. Is that your understanding?
Yes, Your Honor.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
You have no objection, Judge.
It's admitted. Is there any evidence that Mr. Hill's not competent?
None at all, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so we can get that pre-sentence report done, and then we'll come back later for sentencing. On your way out of the courtroom today, you need to stop and talk to probation, and she's sitting at that desk right over there. Okay, we'll see y'all back at sentencing.
If you found this video informative, please like, subscribe, and turn on the bell icon so you never miss the latest courtroom hearings, legal updates, and case analysis.